The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. We are here this afternoon for the submission of 3 cases. The case of State versus Morgan McMickle is hereby submitted without oral argument. Our first oral argument this afternoon is in re the detention of Stewart Schuman and the State of Iowa. Looks like the parties are ready to begin. Ms. Hines?
May it please the court, counsel. The state is here today to ask the court to answer a very discrete question about whether a person other than a treatment provider at the Civil Commitment Unit for Sexual Offenders can develop and accept a relapse prevention plan, RPP, which is a requirement for suitability for transitional release. The state urges this court to find that the court erred in finding that Mr. Schuman, a civilly committed sexually violent predator, should be placed in a transitional release program following the final hearing on annual review under Iowa Code 229A.8. Iowa Code 229A.82 lists the criteria the district court must apply in order for a sexually violent predator to be suitable for transitional release. Iowa Code Section 229A.2D requires that a detailed relapse prevention plan has been developed and accepted by a treatment provider that is appropriate for the SVP's mental abnormality and sex offending history. Here, the state's expert testified that there was not an RPP accepted by his treatment provider. He did believe that there was a detailed RPP that had been developed, but he recognized that this had not been accepted by a treatment.
I kind of don't really like either party's position in this case. I don't like the district court just getting to decide whether the RPP is valid or not, because the statute says it has to be accepted by the treatment provider. So the district court's view is not really the answer. On the other hand, what I understand is the treatment provider here didn't even see or consider the report because Mr. Schuman was in level 3, and that was the policy is until you're in level 4, they're not going to look at it. Am I right about that?
Testimony to that effect. I think it's not entirely, I think the state's expert wasn't entirely sure that that's how it works. She thought it was. But Mr. Schuman was in phase 4 for 4.5 years. And during that 4.5 years, he never had a relapse prevention plan accepted by a treatment provider. So
does the treatment provider have to be someone from the CCUSO's office?
he's treating the SVP, and that is who is aware of their progress during of their treatment program. Moreover, the transitional release program is actually phase 5 of the treatment program. So it makes sense that it should be a person with CUSCO that has the final approval of that plan.
Statute also say it has to be the treatment provider, not a treatment provider.
Statute said
Specific treatment provider, right? Like his treatment provider.
he has a treatment provider at CUSCO. I want to reiterate that Dr. Roselle, his expert witness, is not a treatment provider. So yes, as long as a treatment provider accepts it.
The judge spent a lot of time debunking the transfer from level 4 down to level 3. And yet that decision, I believe, is an internal CUSO decision, correct? And is that part of their treatment? That the decisions that are made involve their treatment?
Yes, in this case, the district court, I believe, kind of exceeded his role in terms of putting himself in the place of the treatment provider and deciding that it wasn't a worthy reason to be demoted to phase 3, which was the failure of 2 lie detector tests. But our witness, Dr. Salter, testified that it wasn't simply the lie detector tests that put him back in phase 3. There was partly, she implied that his failure to proceed in phase 4 was a little bit of that element too. She said that if he'd had a relapse prevention plan that had been accepted, they might not have demoted him to phase 3. So the district court also took issue with the polygraph's reliability and the PPG's reliability, and dug in on the kind of specifics of treatment. And I think that led it to make the wrong decision about who made the ultimate suitability findings about suitability for transitional release.
If that testimony is correct, I mean, if the treatment provider never considers, if there is an RPP out there, but it's never considered by the treatment provider, what do you do then? That seems to me that the state could simply defeat one of the requirements of the statute by, just by, kind of acting arbitrarily, right?
I think Mr. Schuman testified that he did give it to the treatment providers. They just didn't accept it. So that, well,
That failure to accept it arbitrary, or is that within their role?
expertise as therapists at Cusco.
Is approved? I mean, they did not endorse it in any way. Is that correct?
The parties and and the state used the word approved. The statute says accepted, and accepted must mean approved, because it's not a matter of just handing it to them. It has to be, I just can't imagine a different interpretation of accepted than approved in this case, and that is how the experts.
Familiar with this chapter, but I don't think there's any provision anywhere in the chapter that allows the court to do something for good cause, is there? To do otherwise? If there's that statutory laundry list, but none of those include or good cause.
There's a laundry list, and they all have to be found. And again, transitional release is a different creature because it is part of the treatment. It is phase 5, where they're living actually at Cusco in a different building, but they're living at Cusco. They're not, and transitional release, at least as operated in my understanding, is they're not out in the world yet.
Constitutional to effectively give the state expert a veto power?
Because Mr. Schuman doesn't have a due process right to the treatment of his choice, and not a due process right to the transitional release program. Moreover, the criteria is reasonably related to the purpose of to Chapter 229A, because it encloses the treatment process of phase 1 through 5. The district court erred in finding that anyone other than a treatment provider at Cusco could approve a relapse prevention plan. And this court asked, or the state asked that this court reverse the district court's ruling. For one moment, I would address the jurisdiction question. The appeals of these final hearings in which either transitional release or discharge has been granted or denied are across the board. And it's recently in Taft has had several cases before the appellate courts, often coming between annual reviews where he's in a different position when he started the appeal than when the court considered it. I think that is a reason that Mr. Adams is probably correct that it is not a final ruling, that the district court does intend to do something more. But in this case, the state would ask this court to treat its appeal as a petition of certiorari, and its claim that the district court acted illegally. Moreover, this claim.
Before the final hearing, they have to have, first of all, there's a presumption that they stay where they are. and that's 229A.8 sub 1, that the rebuttable presumption is the commitment should continue. Okay. It can be rebutted when facts exist to warrant a hearing. Now, and then a little bit later on, it says, if warranted, the court will set a final hearing. Is having that plan part of the determination to get a hearing?
No, it's not. Mr. Schuman had to present reliable, relevant information to the district court that there was some change in his mental abnormality that would justify hearing.
To get a hearing, and then the laundry list applies only at the hearing?
The practice has been for the state, basically, if there's evidence presented, doesn't challenge that suitability for treatment at that point. It would litigate it at the final hearing.
One where they're saying, I'm not even pretending to say that I want to that I want to be completely released, that I just want to do the program. Is that odd? Is that unusual?
I think that this, Mr. Schuman tried to figure out what would be in his best interests at various parts of his treatment, including lying on a polygraph that sent him back to phase 3. I think that statement is probably also a matter of, you know, if I think I can't get discharged, I think I can get transitional release because I'm willing to do the work. So it's unusual for, I think, you know, I take him at his word. He's willing to do the work.
Is there any dispute by the state that he qualified for a hearing?
No, there's not.
Still troubled by this notion that, I mean, is the evidence indicate whether the treatment provider even considered this RPP?
I don't think there is anything in the record to that speaks to that one way or another.
Developed it. That's sort of the other verb there.
According to Dr. Salter, it may be that Mr. Schuman, at one point in one of his relapse release prevention plans, copied another inmate or another SVP's relapse prevention plan. I believe it's done by the SVP himself with probably the guidance they have gotten from being in the program through phase 4.
It's supposed to be specifically or individually tailored to that person, so copying another inmate's wouldn't be a good idea.
If we're getting to the nitty-gritty of the relapse prevention plan, which Dr. Roselle found sufficient, then I would encourage you to take a look at it because many of his planned responses to like encountering children are simply to stay away. It's not, I would think that there would be other behaviors he could use to control his behavior when he is around children other than just to stay away. And that's the kind of thing that
A.8 sub 5 sub G. If the committed person has not filed a petition, this is the part, or has filed a petition for discharge or for placement in a transitional release program without authorization from the director, the court shall first conduct the annual review as provided in the subsection. So that tells me it is possible to go ahead and get to the next level, to not have the program. You don't have to have the authorization to get to the hearing.
Well, often, the hearings are basically on two subjects by statute, or as provided by statute, which is one is discharge, whether you have changed your mental abnormalities, such, and the other is transitional release. So I don't think except for this, seen a hearing where only really one of those options were at issue.
If we do what you are asking us to do and reverse the district court, then he stays at level 3?
I think that Cusco would be in charge of, figuring out where now he belongs. And I think it would just be a matter of being back in the Cusco treatment area as opposed to the transitional release area of the unit. It sounded like he was working towards applying to go back to phase 4 at the time of the hearing, and that's how it would be done. So, The state respectfully asks this court to reverse the district court's ruling ordering placement of Mr. Schuman in the transitional release program. Thank you.
May it please the court, counsel. Thank you, Your Honor. To be clear, the jurisdictional issue, that issue was raised. I believe the state has remedied the problem that I saw. Justice Waterman reminded me about, or guided me into considering whether there is a right of final appeal in these kinds of cases. He directed me to a case. I looked at the case, and there is no final appeal, or I'm sorry, no right of appeal in these cases because they continue under the jurisdiction of the court. When the state asked that their appeal be treated as a writ or a petition for writ of certiorari, I believe they fixed the problem. That issue, in my mind, is now moot, and the fact that the court is hearing us argue is evidence that the court granted that petition. The fighting issues, as counsel pointed out, is whether what we make of the requirement that an individual to get into transitional release have a relapse prevention plan that has been accepted by the provider. If you accept the state's reading or the state's analysis, that is unconstitutional, because what it does is it allows a treatment provider who in many cases in CUSO are not doctor or even master level treatment providers. For a long time, they had a person up there that had a PhD in vocational rehab doing treatment.
Here's the problem that I have with that, Mr. Adams, is, you know, he was not seeking actual release. I mean, he said, all I want is transitional release. So in that sense, he's kind of, you know, he definitely has a very significant liberty interest, don't get me wrong. 229A is a very significant restraint on a person's liberty, holding them when they've completed their criminal sentence, and that's a significant issue. But if he's not actually seeking release, he's sort of targeting a specific program that's been set up voluntarily by the legislature with certain criteria, then doesn't he have to meet those criteria?
Criteria, Your Honor. The short answer is yes, he should, and yes, he did meet the criteria. You cannot take, this court ruled in Detention of Matlock that as long as one of these people, these committed sexual predators, has a mental abnormality, the court may apply restraint, restrictions, incarceration, whatever on that person. This is an identical situation. They are both conditional release programs. And the code section, in the definition section, 229A.2, and my copy of the code is subparagraph 13, but I think it's now 14. It defines that term. Also, this court's decision in the detention of Anderson, cited by the state at page 15 of their brief, also says that both transitional release and with release with supervision are conditional release matters. They are completely different, well, not completely, nothing is complete. It is different than being in what they call the committed side, phases 1 through 4. That is the committed side. They never leave the building except to go outside in a fenced-in area and go to medical appointments with shackles, restraints, and staff.
the laundry list, because I think that's where, at least I'm getting hung up on. It says in 229A.8A, a committed person is suitable for placement in the transitional release program if the court finds that all of the following, it doesn't say kind of maybe a little bit squishy all, it says all. And so even though the state has the burden at this juncture, that paragraph D, a detailed relapse prevention plan accepted by the treatment provider. Okay, maybe that's where the weakness is, but didn't the burden shift at that point for the defense counsel at that point to talk about the things such as Justice Mansfield just mentioned? What do you mean that's not approved? It's done, it's been completed. Wouldn't the burden have shift for you to try and show that that actually, in your opinion, has been accepted? Because first blush, the record shows it has not been accepted by the program.
I agree that it has not been accepted by the program. The problem is that is an arbitrary process. The program did not even consider Mr. Schuman's plan.
Legislature, if you think it's an arbitrary program, I mean, it's statutorily, as Justice McDonald said, by the person, the treatment provider. I mean, this is the language that we're given.
Exactly. But this language, Your Honor, conflicts with Mr. Schuman and everyone else's rights to due process under the Constitution, federal and state Constitution. You said, this court said in Matlock, that the trial judge must balance the individual circumstances and the person's interest in freedom against societal interest in remaining safe from this potentially dangerous person. By putting that decision in the hands of the treatment provider, you're taking it away from the district court.
If we don't conclude that there's a constitutional violation here, then would you agree that the statutory requirement as written hasn't been met?
No, Your Honor. And
Is satisfied. Sub D.
I think that if the court follows the state's logic, that would result in an unconstitutional situation.
Is if we disagree with your premise that there's a constitutional violation here, have the terms of this statute as written been satisfied?
Determines that I am wrong, there is no question that the statute has not been satisfied in that regard. I believe, however, this court can find this statute as written to be constitutional. And what plays into this, and the trial judge had a lot of problems with this, is a proof issue, the expert hearsay rule. Hearsay comes in because experts rely on it, but this court has said that that's not a way to shoehorn inadmissible hearsay into the case.
It's a statute. Some of the criteria are just historical facts. Has X been done? Has Y been done? One of those X's is D, the treatment provider, the person actually providing the treatment, has to accept a plan. That's a yes or no. Another example, the offender has not had discipline reports issued for a 6-month period. That's a yes or no. I don't see any qualification that says, well, unless the judge thinks that the disciplinary reports weren't legitimate, blah, blah, blah. And then there are some that incorporate the district court judge's discretion, like best interests of the committed person, demonstrated a willingness to agree, da-da-da-da. What's wrong with the legislature creating a statute that requires some historical markers be met and then gives the judge discretion as to others? Why is that problematic?
In this case, because you're dealing with a person's liberty, Your Honor, on one hand, and societal safety on the other. It is the duty of the trial court to mediate between the state and the respondent in these cases. If you let CUSO or a treatment employee employed by CUSO make the decision, it is usurping the trial court's duty and function. And what I suggest...
The legislature gave the trial court the discretion. If the legislature said, you have to decide the case this way, and we think the statute is constitutional, then your argument kind of presumes the answer to the question, which is the trial court should have discretion where the legislature didn't provide it. And because the legislature didn't provide it, he should get discretion. Right? I mean, that's kind of the argument.
Perhaps. I believe the court inherently has jurisdiction or
Should we be delving into that? I mean, this judge made a comment that Dr. Salter also discusses, I can't even pronounce it right, penile plethysmograph, whatever, PPG, administered to Schuman, blah, blah. And he goes around and he talks about that. And this has to do with going from level 4 down to 3. Aren't we interjecting ourselves in something where we're not the experts, that they are the experts dealing with that program? They're the ones, I think that for whatever reasons, I think the judge even said it's disgusting to kind of talk about some of these things. But that is what they do. And they know a lot more about sex offenders than the court does. We understand discretion when we're given to it. But some of those statutory laundry list things, they do put the burden on CUSO to do their homework. Why is that wrong?
it's not wrong, Your Honor, but the legislature gave the court the function or duty to oversee and preside over these disputes.
This middle view, I mean, normally you read statutes, so, I mean, certainly like you read a contract, so there's some sort of duty of good faith in it. And it strikes me that where there's a statutory requirement that a designated individual have to accept the detailed relapse prevention plan, I think one could argue that that implies some duty of that on the part of that individual to at least look at the plan and then say yay or nay. And if they say yay, nay, that's the end of it. The judge can't go any further. Is that, I mean, is that a possible line of argument? Would that be supported by this record?
The record in this case, Your Honor, is that the state's expert was informed that Mr. Schuman had not reached phase 4 and therefore automatically knew that he had not had a relapse prevention plan accepted, because they don't accept relapse prevention plans at CUSO until the person is in phase 4. That is.
They never looked at it. Justice Mansfield saying that, is there, okay, so there's no evidence, I mean, there could be, they could have shown it to the provider and it just wasn't accepted.
But what you're saying is the evidence is that if he's in level 3, it's not something that would be considered. What exactly is the testimony?
That. So is there any evidence showing either it was shown to them and they just looked the other way, or is there no evidence that whether it was accepted or shown to them?
My recollection is Mr. Schuman testified that he submitted it. When asked what happened, his response was, I don't know. I don't know.
According to the record?
And I guess that depends on how much faith you put in what he said.
Here's a little bit more of where I'm coming from. I mean, you make a showing to get to a final hearing. Everybody knows he's in phase 3. Everybody knows he's seeking transitional release. Everybody knows that the RPP is a requirement of his being shifted into a transitional program. I mean, why we waste, you know, it seems like this is a big waste of time if at the end of it, the state can just say, well, you know, he was in phase 3 and they don't accept treatment plans as long as you're in phase 3. I mean, that seems to me kind of it does make a lot of sense. I haven't figured out what to make of it legally, but it seems like a waste of everybody's time.
Arbitrary, Your Honor. It's this time, they have time frames for each phase, that a person has to be in each phase. And I think the record bears that out.
3 months between the final hearing being ordered and the final hearing taking place, right, approximately? So there was enough time to make a record on this issue, right?
Was.
Discretion cut both ways. You said that the district court has inherent authority to do the balancing and can ignore the statute to balance. So let's say the plan was accepted and we came to the hearing could the district court judge say, I don't think this is a real acceptance because in my view, the RPP isn't sufficient and doesn't meet the safety objectives of the community?
Honor, to answer your question, that is a matter of proof. The state, and also to address a question that someone else had, the respondent has no burden of proof once he has got himself a trial, ordered a final hearing. Then the code says burden shifts.
The state could litigate that. They could say, despite the acceptance, we don't think the court should deem this a real acceptance because it doesn't appropriately balance safety and liberty. Okay.
I would expect that the state would come to court with live witnesses with firsthand knowledge that would give testimony and evidence about what is wrong with the plan. Dr. Roselle has far greater experience in this area than all of us. He's been a treatment provider of sex offenders and evaluator his whole career, 30 plus years. He looked at the plan as the former treatment director of Mount Pleasant Correctional Facility, this SOTP program. He looked at it and said, this is a good plan. It should be approved. And, thank you. There was no response to Dr. Roselle's evidence. No response from the state. And the district court was really impressed, or lack of impressed, I guess, impressed negatively that Dr. Salter didn't even delve into that. So,
Question?
Honor.
Should we give any meaning to the words in D that the plan has to be not only accepted by the treatment provider, but developed by the treatment provider? Does that mean anything?
What that means, Your Honor, because, and this was talked about when Ms. Hines was here, the individual safekeeper or individual committee is required to do the plan himself. It's not developed by staff. They coach them. They teach them what needs to be in a plan. They review the plan, provide guidance for modifications. But CUSO itself doesn't create the plan. And sometimes, you know, if it works for one guy, they're going to get together and help each other. And there has from time to time been concern that somebody copied someone else's relapse plan or prevention plan. That's why I think it has to be aired in a court of law with an impartial judge or jury that can look at the reasons that all these things are happening or not happening and say, this is right, this is wrong. I think you can't escape having the court involved in matters of deciding a liberty for an individual, which is probably the highest freedom we have, and public policy, or I'm sorry, public safety, which is probably one of the highest responsibilities we have.
Role, as you describe it, includes second-guessing CUSO's decision to move him back from level 4 to level 3. So that decision is beyond our review or was correct. Where does that leave us? Is that a valid reason not to accept the relapse plan?
What I believe the trial court did was use that information that consisted of polygraphs, penile plethysmographs or PPGs, as those things are generally not admissible in court because they're unreliable. And the trial judge was looking at what this expert put in her basket to justify her conclusion. And he found that that was not a valid, legitimate reason to rely on something that is so unreliable. And
We don't have to follow the rules of evidence in this kind of a proceeding, correct? Isn't, and the 229s, or isn't it in the code that the rules of evidence do not apply? Is that correct?
portions, Your Honor, such as a probable cause hearing, where they just filed a petition, there has to be a determination of probable cause. The code specifically says rules of evidence don't apply.
Question, because you're not coming back up. Ms. Hines made a comment, and she can correct me if I'm saying it wrong, or you can correct me too. But I think she said, even though he was on level 4 for 4 years, he didn't ever have a plan then. Is that true?
He had a plan and he submitted it.
Approved?
That was not in this record, but I believe
The fact that, you know, it was just, or at least the court was relying heavily on the fact that he bumped back down makes it sound like when he was on 4, he was doing great. But to your knowledge, there's no record of an approved plan when he was on 4?
was approved, Your Honor. I don't have anything in my memory of this record, but I believe Mr. Schuman addressed that in his testimony, that he was there. And people that are in transition that aren't, or in phase 4 that aren't doing what is expected of them can be removed from that level and dropped a level. If there's misconduct, commission of a crime at the facility, they can be moved down a phase. Thank you.
Okay. Ms. Hines.
In closing, I would ask that the court affirm the decision of the district court. Thank you.
May it please the court. I'll just be brief to answer your question. I think that the testimony of Mr. Schuman was that he did give his treatment provider RPP and then didn't hear anything else about it. So I don't know that, I don't think the record shows that it was accepted by a treatment provider. The other thing I just want to address, I can understand Justice Manfield's confusion about why it wouldn't just be automatically you don't have a hearing on transitional release if certain criteria aren't met. And I can't answer that because but I do think that is a problem with the way that this has been.
And the reason why that might be relevant is normally we interpret statutes so they're fair, reasonable, and make sense.
Somehow the pattern and practice has been for everybody to litigate both issues of discharge and transitional release. I'm not sure that transitional release should be litigated if at the annual review there is two criteria that are not discretionary. That is the disciplinary report and the relapse prevention plan. So those things, if they aren't present, I'm not sure there should be a final hearing on the issue of transitional release. But
that the offender could request a hearing in the expectation that he has a plan that's getting ready to be approved. And he wants to facilitate this, so.
the only unfinished
Approved by the time the hearing rolls around, then you've got a proof problem.
Counsel, do you think that, you go ahead, sorry. I was going to ask about Matlock. Why is the other side wrong that this case is sort of similar to Matlock in its due process challenge?
Matlock was released on supervision, and the district court had to make sure that the conditions of release were appropriate for him and his treatment. Here, the whole issue of whether there should be a transitional release was at issue, and the criteria listed by statute was the only. I mean, that criteria is partly discretionary and partly conditioned upon the. I think it's D and the disciplinary report are kind of just factual, but there is a discretionary component to it if those two things are met.
We read into the statute a requirement that the state exercise good faith and actually review the plan. And
I think you can do that, and I think that if for some reason somebody's at Cusco rubber stamping, no, not approved, ultimately Mr. Schuman would have some kind of judicial review options through 17A. Thank you.
In the detention of Stewart Schuman is hereby submitted. And we'll have a brief pause while we prepare for State of Iowa versus Lobb. And also earlier today, a case of Iowa Supreme Court Attorney Disciplinary Board versus Neff. We did not mention, but it is hereby submitted at this time as well.